live.
Judge, I think you are good with me now. I am here. If you need me, give me a call.
All right. I thank you, Keith. I think you're right. We're done. All right, we're where we need to be. Okay, I'm going to turn the record on. We're about to start our pre-exam conference docket, and we're very busy with that as well. We've got Attorney Tim George, we've got TJ Reed, we've got Paul Gibson, we've got Casey Johnson, we've got Melissa Halleck. So let me figure out who some of these people are.
Your Honor, this is John Bush. I have a sentencing set for 9 o'clock. Is that still on?
Who is it?
Chase Hardy?
Yes, we're going to need to have the jail bring him in. I thought it was set for.
Deputy Shabbat, how can I help you?
Good morning, Deputy Shabbat. Judge Middleton, can we see Chase Hardy down at the Polycom room?
Yeah, we'll come to you there,
All
sir.
right, thank you. Bye. All right, let's see who else we've got here. I have a telephone number. Who's 269-718-749? Who am I speaking with?
That's Bethany Hagvu.
All right, let me give you a name. All right, we've got Denise Baker, Devontae, somebody, Peter Pearson, and Sanford Schulman. I'm going to bring everybody in and let me take it back out. Let's see who's got the least. Melissa, I think, is the duty attorney. Mr. Schulman is here on a case. Melissa, we'll set your cases aside here for just a minute.
Okay.
Tim, what have you got?
Your Honor, I have Dwight Summy. He has 2 different cases, and the appointment just went through late last week. Spoke to Mr. Marvin this morning. At this point, because of the lack of time, we're just going to keep it set for a prelim. I did talk to Dave. I have a issue with the scheduling for next Tuesday, so we've agreed to ask for the prelim to be set on the 15th.
All right. That was Luke's, now it's yours.
Yes, sir.
All right, he is in custody. There are 2 files.
We can't hear
File 21886FY is a CSC1, 2 counts, and 21887 is a CSC. All right, let me make a note. Have you discussed this with him?
I'm going to call over to the jail this morning, Your Honor.
Well, I don't have a waiver of the 14 days.
I can get that. I can speak with him about what's going on, and we can get the paperwork executed.
All right. So we're gonna set prelim, both cases,
First things first.
for June 15th, 1 p.m. Devontae, you're jamming us up here. I'll mute you. So is Bethany. Bethany, just be quiet if you could for a minute. I'll put T. George will get 14-day waiver.
Hello? Hello?
All right, yes, we're here, so just stay where you are. Particularly the people that don't have a video, can't tell what's going on, but there are a number of people logged in here. So we're struggling with all that. All right, now I'm gonna bring in Deborah Davis and John Barnes back. Mr. Schulman, good morning to you, sir.
That should be it for me, Your Honor. I'm going to log out.
All right, thank you.
Thank you.
Judge, I
Yes?
am here as city attorney on Dylan Pendleton and Jared Norris.
All right,
At this point, there's no offer. They can just be set for pretrial.
okay.
So I got notice for today. So I appeared. They can just set them for pretrial, and if you
You
need.
appeared and now you can disappear, okay?
All right, thank you. Have a great morning.
If I need you, I'll send you something, thank you.
All right, I'll be at my desk.
Mr. Schulman, can you hear me?
Yes, good morning, Judge. How are you?
Good, I had a professor at Wayne State, Stephen Schulman.
Yep, that was the uncle. He was the corporations professor.
Yes, he was. He was an excellent professor. He's passed,
Yeah.
but I can tell you this story if no one ever told you this before. He used to button and unbutton his coat when he would give a lecture. And he'd be lecturing and he would button and unbutton his coat. So we would take a pool on how many times he would button and unbutton his coat. It was a quarter to get in it. And so the class was an hour and a half long, and people weren't focusing on what he was saying, they focused on how many times he buttoned and unbuttoned his coat. Anyway, so then people would laugh and he would have no idea what it was about. But anyway, you can share that with your family. Good morning to you, sir. I'm a 1981 Wayne State Law School grad. Mr. Pearson, are you here with us?
Mr. Pearson should be here. Yes, he is.
He is here. He needs to unmute his mic. I never did win the pool, by the way.
Well, he had other probably more damaging. He was a smoker, so I know that was far worse.
Yeah.
For him.
I liked him. I thought he was a good professor, and corporations were not my forte. Mr. Pearson is charged in file 21503FY with embezzlement over $100,000. That is a felony. Let's click it up here. It's alleged that through June of 19, you embezzled more than $100 from the Lorraine Alexander Family Trust. It is a felony punishable by up to 20 years imprisonment. Who's handling this one? Deborah, is that yours or Casey's?
No, it's David Marvin is
Okay.
actually handling it.
He's
I don't
been
believe that we've had any contact from the attorney, so any one of us can handle it.
All right. Mr. Schulman, have you had an opportunity to talk to anyone?
On this case of Peter Pearson you're talking about?
Yes.
Yes. In fact, David Marvin appeared last time, and he's been in touch with me about at least a half a dozen times.
Okay.
And,
Dave is here. He didn't have any notes in here about this one. I can check with him.
yeah,
Is the defendant going to waive the preliminary examination, or do you want me to set it for a hearing?
That was the big question. Mr. Marvin was contemplating a misdemeanor. There's a lot in this case. The discovery itself is about 1,500 pages. So I was hoping to not have to have an exam and we could work it out. And that's the posture of it. I don't know if you're inclined to give us another PCC, but he said on Friday he was gonna, on Thursday he was gonna contact me on Friday. I had not heard from him, but he's been very.
Well, on Thursday, we lost power here at the courthouse. The courthouse was unexpectedly shut down, so things were disrupted.
Okay.
So let me just mute you and Mr. Pearson. Perhaps Mr. Marvin can join us. And
yeah, that'd be great.
Hey, can I ask a question? So the cops broke my phone. Are they gonna?
Mr. Scott, I'll come back to you later. Mr. Pearson, I'm going to mute your phone also.
I'll mute.
All right, John, Mr.
I got a Chase Hardy sentencing at 9.
Yes, he's here. John Bush is here.
All right.
He has 85 days credit.
He was sentenced on Friday to DMCA.
Yes, I watched it. Good morning, Mr. Hardy. This is Judge Middleton. This is the time and date for sentencing in your impaired driving case, which is file 202638. You were sentenced last week in your felony cases. I watched it. It was hard to watch. You've got 85 days credit. Mr. Bush asked that we set this after your felony sentence so it wouldn't affect your sentencing guidelines. I'm going to give you 85 days jail credit, 85 days. Leaving 0 days to serve, and I'm going to waive all your fines and costs. You may be released to the Department of Corrections. When you pled to this, Chase, you were quite thoughtful, regretful, remorseful. You were at the bottom of the pit, and it all caught up with you. I think at some point we may have some bond in here. Let's take a look. You certainly had a lot to think about over the weekend. I have a $300 bond. So I'm going to do a $75 crime victims' rights fee, $50 state minimum fee, and a $175 bond. I think it might be 10%. It's 10%. So $300 bond is $270, so $125. Is 145 fine. I used your bond to pay the minimum fine. I gave you credit for 85 days, which frankly, with good time, an OUID wouldn't would be about 85 days. You get 5 days a month. Chase, I wish you well. A while before I see you again. But this matter is over and done. There's really not much else to say about it. Mr. Bush, we discussed time served when we were discussing this previously, and the clock is ticked further. And that's the sentence. Chase, I wish you the best, but this matter is one less thing you have to worry about. You may be released to the Department of Corrections.
Chase, I wish you for the best. Good luck.
Thank you.
All right, thank you.
Thank you, Judge. That covers me this morning.
All right. I'm going to leave the jail on the field. We may need someone else. And that
Judge.
Yes?
Prosecutor Marvin's gonna log in so you can put him into a breakout room with Mr. Schulman.
Great.
All right. He hasn't logged in yet. I'm waiting for him, but
Yeah, he was working on some other things, but I just saw him walk by my office, so it should be momentarily.
all right. I'll set aside Pearson. Now, I've got a couple other people in the breakout room. Paul, what have you got?
I was here because one of the notices I had said that Dylan Pendleton had a bond violation arraignment. I'm not sure if that was a mistake, but I got a notice for it, but it's also...
Oh, he also violated his bond.
I know he's in jail because I saw him on last week at the jail.
Well, is that your case or Melissa's?
There are
Well, I
two.
guess I subbed in for
Okay,
Melissa, I
yeah.
believe.
File 21972 is possession of methamphetamine, carrying concealed weapon, and felony firearm. That's Mr. Gibson. And his surety bond was canceled. And there's an allegation that he violated his bond. I set it at the same time as his prelim, and file 211020FY, which is Melissa. All right, well, let's take a minute. I'm gonna put the conference room back in the waiting room. That's Mr. Scoggin. And I'm gonna bring Mr. Marvin in. Good morning, Mr. Marvin. Mr. Schulman is here, and Mr. Pearson is here. Apparently you and Mr. Schulman have been in discussion in this case, and we weren't privy to that. So I'm gonna put the two of you in a breakout room so you can discuss this, and then we'll see you in a few minutes, all right?
Thank you.
David Marvin and Sanford Schulman, not Stephen Schulman. Mr. Schulman, you need to unmute your mic. And Mr. Pearson, I'm gonna put you in the waiting room, all right?
Okay.
All right, now, we've got Melissa, and we can focus on her cases. Melissa, I have Denise Baker in the waiting room. I have someone from Galaxy A10. Let's find out who that is. And I got Devontae West. Galaxy A10 is joining us. Can anyone tell us who this is?
Not from that angle.
It looks like inside of a roof.
not coming up on mine. Oh, there. It's frozen. I'm guessing Justin Scogan.
No, Mr. Scogan's in the waiting room.
Nope, not him.
All right, Denise Baker is back with us. Devontae West is with us. Mr. Scoggin is with us. Bethany Hoggerbo is with us.
That would leave Anthony Engelmeyer and Calvin Bridges.
They're in custody.
Reggie King?
No, it's not Reggie King.
Oh, I thought you said Bridges and Anthony Engelmeyer.
Yeah, I'm trying to figure out, like, I don't know what some of these defendants look like. Jared
All
Norris.
right, let's talk about what we do know for the time being. Denise Baker is here. That is file 211059. She's charged with possession of methamphetamine. What are we doing in that case?
I spoke with the prosecutor, Dave Marvin, Friday afternoon. He offered to allow her to plead guilty to 1 count of use of methamphetamine, a misdemeanor, and that he would not oppose 7411.
Have you discussed that with her?
No, I did not get the chance to.
All right, Ms. Baker, stay right where you are. And I only opened 1 breakout room, so.
Hello.
Hello, Mr. Galaxy A10, what's your name?
My name is Dwight Summy.
All right, Mr. Summy, we thought you were in custody. Apparently you're not. My instructions are for you to call your attorney, Mr. Timothy George, okay?
Yeah, I just did that, and the office is closed, it said.
All right. Well, they wish to set your preliminary examination. He wants to talk further to the prosecutor for June 15th. Is that acceptable to you?
That's when the next court date is, or do I have to come on the 8th?
No, it'll be on the 15th. All right. I want you to call your lawyer. His office will be open later, but your bond is continued. You're not to have any contact with complaining witnesses, and your prelim has been set for June 15th, not June 8th.
Okay.
All right.
Okay.
Okay.
Okay, thank you.
All right. Call your attorney.
I will.
All right. So we're waiting on that one. So that's an offer there. Baker, what about Devontae West?
So since I spoke with Dave, I didn't get a meeting with him until late Friday. I didn't get to convey the offer, but there is a new offer in his case that I did not get to discuss with him.
All right, we'll do a breakout room with him also. Mr. West, your lawyer is here, and I'm going to put you in a breakout room with her in a moment so you can discuss this further. Now, we have several people that are in custody. Anthony Engelmeyer, Calvin Bridges, Miles Bridges. We have Reggie King, Jared Norris, and Christopher Pontus. So we'll take care of our in custody people after we take care of non-custody. Do we know anything about any of those, Melissa?
Yeah, I mailed waiver or faxed or emailed waivers to the jail for Anthony Engelmeyer.
All right.
He'll be waiving either when we get the form or on the record.
All right.
Dylan
Pendleton.
I discussed with him waiving in my case. I believe that's what he planned on doing.
We'll bring him in a bit.
Okay. And then Chris Pontius would be a waiver. And he would like to be heard on bond.
All right.
And then Jared is a waiver.
Who? Jared Norris?
Jared Norris. And then
All right.
I had a note from my assistant that Reggie King was not in custody. So when she calls the jail, she gives them a list and they confirm or not confirm.
Let's take a look. See whether he's on my list.
Because he had not contacted me. And then I never asked at the jail because I didn't know.
He's not in jail.
Oh, okay.
We'll call him.
Bethany Hagenboo, she's on the line. She's called in
Yes.
already. She's going to be a waiver.
All right, well, let's talk to her. If I can find her file. Ms. Hagaboo, can you hear me?
Yes, I can.
This is Judge Middleton. I'm here at the court in Centerville. Laura, could you bring me a bind over in the Bethany Hagaboo case? Let me get your file up here, ma'am.
Okay.
The allegation is that on or about February of 21, that you engaged in sexual contact with a person under the age of 13 years, 2 counts. And those are criminal sexual conduct in the second degree, which is punishable by up to 15 years imprisonment. This is the time and date set for a preliminary examination in this matter. A preliminary examination is a hearing where it must be established that a crime was committed by a standard of probable cause and probable cause that you did it. By waiving the preliminary examination, you're not pleading guilty to anything or waiving your right to any further trial. You're simply allowing that the prosecutor could establish beyond probable cause that a crime was committed and that you did it. Do you understand?
Yes, I do.
All right, let me read you the language. I, Bethany Ann Hagaboo, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do?
Yes.
All right, thank you. Melissa, you've got all of her contact information?
Yeah, can I confirm, Bethany, we had sent you some emails. Did you get those?
I had gotten the one that was the waiver and I signed it.
Okay. Do that.
Well, we just did it on the record here.
Yeah, I'm just okay. I just wanted to make sure she got the emails because we had discussed it, and then I don't think I had got the waiver, but she must. I'm just wondering if it didn't come through. But okay, so we have the correct email. Yep, just keep in touch with us, and we have her contact information, so we're good.
All right, bond has been posted in the amount of $15,000 cash or surety by a surety company. The next step in the procedure will be a status conference in the circuit court, maybe some weeks before that happens. All the bond conditions are in place. No contact with a complaining witness, no getting in any other trouble, you can't leave the state. Do you have any questions?
No, Your Honor.
All right, you're good to go. Thank you.
Thank you.
I should confirm, Deborah, that people agree with the waiver.
We do, Your Honor. I'm actually signing the information right now.
All right. All right, now, Melissa, we've got Mr. Scoggin in the waiting room, and we've got a plea to take on Miss Baker. So why don't we do her, and then we will, oh, you want to talk to Miss Baker? I'm waiting, oh, David is back, and Mr. Schuman is back. So let's see what we're going to do with that. We return, let's bring Mr. Pearson back. Got a ballet going here. We return to file 21503FY. It's entitled People versus Peter Matthew Pearson. His attorney Sanford Schulman is here and prosecutor David Marvin is here. Mr. Marvin, what's the status here?
Your Honor, we had a discussion. This is going to be bound over, and we're going to continue a resolution in circuit court.
Mr. Pearson, can you hear me? Laura, could I have a bind over on Peter Pearson?
Judge, while you're getting the setup, I did forward to Mr. Marvin an executed waiver of the preliminary exam that was signed by both.
All right, then that'll be sufficient. Mr. Pearson, can you hear me? Well, he was here, so a waiver is on the way.
Yes,
I'm
it
here.
is.
All right, Mr. Pearson, did you execute a waiver of preliminary examination that was sent to you
Yes.
by the attorney? And you understand the matter will be bound over to the circuit court for further discussion and proceedings in that court. Do you understand?
Yes. Yes.
Are you still living in Bronson?
Yes.
Okay. Do you have any questions?
No.
All right, stay in contact with your attorney. He seems to be on top of this. I don't know yet where this is headed. I don't really know anything about it other than the very brief thing I read to you. All right, the matter will be set for a status conference in the circuit court. When the waiver catches up, we'll file it.
Thank you.
All right,
Thank you,
Mr. Schulman, nice to meet you.
Thank you.
And I don't know, I'll put it in here. You're both free to go. Thank you, David. Now, what I'm going to do is close the waiting room, the breakout room, and reopen it so that Melissa can use it to talk to Mr. West and Ms. Baker. All right, Ms. Baker, I'm going to put you in a separate room with your attorney so you can talk with her. Mr. West, stick around. We're going to do you next. Let's go. Mr. West, I'm going to put you in the waiting room so you won't just be dangling out there. I'll be back with you in just a bit.
All right.
Okay. All right, so let me get rid of my arrangements.
Paul, any updates on yours? Paul? You're on mute, but do you have any updates on yours? Oh, you're on mute. Your Honor, regarding Clarence McLean,
Yes.
I don't know if you talked about that before I logged in, but I figured we were just resetting that one because of the forensic.
Yes.
Okay.
Mr. Gibson was there. We made the record Friday, and so it's not set for PEC or prelim. And I advised Judge Pattison that would be off. I'm still waiting for the competency order, but we won't be doing anything on Mr. McLean pending that.
It was still sitting in my queue for today for PEC, so I just wanted to make sure that I.
Well, it's because we didn't get the order yet.
Okay. I think Paul sent over a proposed order. I'll have to look at it.
All right, maybe it hasn't caught up to the file. So we've got, now Casey's still on the feed. Is he gonna get stuck with any of these? We've got David and Casey. I don't need to take up their time if we don't need them.
Yeah, Judge, I think Ms. Davis probably has this under control. So
Okay.
I'm gonna step out. If you need me, I'm here.
No
All
problem.
right, I'll open the door and yell down the hall and say, hey.
Sounds good. Thank you.
All right.
Yeah.
All right, so we got Mr. Scoggin in the waiting room, and he's somewhat agitated. He also had a disorderly person charge from Three Rivers, which Mr. Barnes would forego. He's in the waiting room. Calvin Bridges, I believe, is in custody. Anthony Engelmeyer is supposed to be a waiver. Reggie King, we've lost track of. Well, I was going to call him. Have you ever dealt with Reggie King?
I haven't.
Let me call him. Let me close that breakout room and bring Miss Baker back. But he's a hot potato.
Please leave your message for 269-718.
9642.
Good morning. Is this Reggie?
Yeah.
Reggie, this is Judge Middleton. I'm calling you. You're supposed to be in court this morning. Were you aware of that?
What?
You were supposed to be in court this morning.
That's the first. I thought it was the fucking 20.
No, today is the 1st, and your lawyer is here. Can you dial in?
Yeah. Well, hang on.
Well, all right. I'll tell you what. Can you... I'm going to hang up on you, but I want you to either dial into the court or call your lawyer, Melissa Halleck, okay?
Okay, I got the paperwork and I...
All right, stay where you are. She'll call you in a few minutes, all right?
All right, because I got the paperwork and everything. I'm like, well, because I thought today was fucking 20 something.
No, it's today. So what time do you have to be at work?
I'm going to be at work today.
All right, well, stay where you are. Stay awake. She's going to call you in a minute. All right. Okay?
Okay.
All right. Melissa, do you have that number?
Let me confirm, I guess, which number, because
It ends in 9662.
Hang on. 9662. Yeah, and my computer's going real slow. Oh. Files open here.
I'll email it to you.
Okay.
Now, I brought Mr. West back so you can talk to him in the breakout room. Ms. Baker.
I actually already met with him, and he would, he's not going to accept the offer. We'll set it for a prelim.
All right. Mr. West, can you hear me?
Yeah, I can hear you. Shorty, like, what was that talking about?
I'm sorry, let me call the case. This is file 21839FY, People versus Devontae LaShawn West. Mr. West, you're charged with delivery of a controlled substance less than 50 grams, manufacturing and distributing an imitation controlled substance, 2 counts. This is the time and date for a pre-exam conference in this case. What would be set next would be a preliminary examination, which would be next Tuesday at 1 o'clock. A preliminary examination is a hearing where the prosecutor must establish beyond a standard of probable cause that a crime was committed and that you did it. Your lawyer says you wish to have the preliminary examination. Is that correct? Mr. West?
Yeah, because she, like I said, me and her ain't really talk about the offer. She just texted to me this
All right,
morning.
I'm going to set it, you'll have a week to discuss it further. Right now, I'm going to set this for prelim for June 8th, 21 at 1 o'clock.
I want Mr. West to be aware, Your Honor, on the record, that if he does demand a prelim because this is a sweat case, there will be no offers.
All right, that's something to consider.
Right, my lawyer ain't tell me all that.
Well, you guys will have a chance to discuss that, Mr. West. At this point, you haven't given anything up, except we're going to back this up 1 week for a prelim. You'll have time to discuss it with Ms. Halleck when there's more available time. If you wish to have a prelim, we can do it. If you wish to waive the prelim, we can do that also. Okay?
Attorney Halleck, have you received all of the discovery information, including the lab results?
No, I'm missing no, I don't have it all. I can email you what I don't have.
Email Rachel at our office because we have
Right.
3 different lab sheets.
I have
So-
2 that on the substitute, not the any actual product. So
All right, Mr. West. Melissa, are you going to call him or you want him to call you?
I'll give him a call later today.
All right. She'll contact you later today, Mr. West. I'll let you go back about your business.
I bet.
Okay, thank you. All right, I'm going to bring Mr. Scoggin back in just because he's getting kind of antsy. Mr. Scoggin, we haven't forgotten about you. Stay where you are for a moment. We're going to deal with Miss Baker. We've met before. This is Judge Middleton. Are you Denise Marie Baker?
Yes.
This is file 211059. You're charged with possession of methamphetamine. Prosecutor has agreed to reduce this to a misdemeanor charge of use of methamphetamine. Which is quite a reduction. Possession of methamphetamine is a felony. It's punishable by up to 10 years in prison and a fine of up to $15,000. Use of methamphetamine is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. They've offered, if you are eligible for probation under Section 7411 of the Public Health Code, that's 333.711, we just call it 7411, it would allow you to have this charge taken off your record as a public record of conviction if you successfully complete the probation. Do you understand the charge?
Yes, I do.
Are you going to plead to that charge?
Yes.
All right. Other than that plea agreement, did anyone promise you anything to get you to plead to this charge?
No.
Or threaten you?
I'm sorry?
Or threaten you?
No.
To try to get you to plead? Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or a jury? There will be no trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Halleck has been appointed to represent you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Do you understand? Ms. Baker?
Yes.
All right.
I'm sorry. It broke out the sound out for a minute.
Did you understand everything I said?
Yes.
Okay. Just a minute. Let's take a look. The complaint says that on or about May 21st in the village of Mendon that you did possess methamphetamine. At that time or place, did you use or possess some methamphetamine?
Yes.
All right. Do you live in Three Rivers?
Yes.
How'd you happen to be in Mendon?
Well, I live in the township of Parkville. It's still Three Rivers. I was in Mendon going to my father's.
Okay. Well, you got a stray dog hearing 2 days from now.
Yes.
Who's your dad?
My father?
Yes.
Dennis Baker.
Okay. Dennis, the former dog warden, Dennis, or the other one?
No, he's not a dog warden, no.
Well, there's a couple of guys named Dennis Baker. Yours is the Minden one.
Huh.
All right. Have you ever been charged with, let's see what this is.
I'm sorry, have I ever been charged with?
A drug charge before?
No.
All right. I'm going to set this out for a little bit for sentencing. What do you do, ma'am?
I'm a contractor. I build homes. I do drywall, framing, plumbing, landscaping, pretty much anything around the house.
Okay. Do you have a license?
Yes.
Oh, very good. I'll find out more about that. Let me set this for sentencing. Let's see if we can find a date that works for you. Does Wednesday, June 23rd at 11 work for you, Melissa?
Yes, Your Honor.
I'll need police report. I'd like to hear more about your employment. If you're placed on this probation, it will involve testing. Right now, you have a condition that you not use any controlled substance. I'm a little concerned that I'm letting you bounce around for a couple weeks till we get this probation set up. I'm going to test you the day I see you, which will be the 23rd of June. So this is a hard drug to get a handle on. We'll discuss this further on June 23rd at 11 o'clock. Are you still First Street?
Yes.
I don't know where First Street is. Is that out in Flowerfield? Or it's Parkville?
No,
Parkville, okay. Got it. That little short street. Once upon a time, Parkville was a happening place, not 150 years ago, 100 years ago. It had a church, it had a racetrack, it had a store, it had an auto garage, it had a mill. Now it's just a little white spot in the road. All right, Ms. Baker, I will see you on the 23rd of June at 11 a.m., okay?
All right. Thank you very much.
Thank you. All right, now we got Mr. Scoggin. He's been waiting patiently. He had a misdemeanor disorderly charge, and then he also has a felony charge.
You mean
Justin Scoggin.
Okay.
Now, in Three Rivers, they called him Scoggins, but his name is actually Scoggin. He's charged with resisting and obstructing a police officer. Mr. Barnes was willing to forego his charge if something could be resolved here. We learned from Mr. Scoggin that he's presently homeless. His mother lives in Lawton, and he's camping here in Three Rivers area. He pled not guilty to the disorderly person charge. Melissa, Deborah, is there a plea offer in this case?
You can plead to an attempt R&O, Your Honor.
All right, Melissa, have you had an opportunity to discuss that with him?
No, Your Honor.
All right, Mr. Scoggin, I'm going to put you in a breakout room so you can discuss this with your attorney.
Well.
All right, stick around. Don't go away yet. You've been very patient, and I appreciate the fact that you came over here and you're treating this seriously. But we have a lot of business to transact. All right, So I guess the offer would be 1 count of attempted resisting, obstructing a police officer, which is a misdemeanor, punishable by up to a year in jail. And the city attorney would forego the disturbing the peace. So let me let you talk to your lawyer. If you don't wish to do that, you can have a preliminary examination on the charge next week.
I click join right here?
Well, yeah, you click join.
Okay.
All right, now, Debbie, this probably would be a good time to let the jail know. I left the jail open and they closed it. We are going to need Christopher Pontius, Dylan Pendleton, perhaps, Calvin Bridges. Do you have a position on Mr. Pendleton's bond violation on Mr. Gibson's case in light of the fact that he's in custody on new charges?
It's my understanding that his bond on the new charges is only $4,000 cash or surety. So we do have concerns about him getting back out with the number of cases that he has accumulated and the fact that there's weapons and meth.
He has a $25,000 bond in file 21972. Have you already posted that?
He was out on the one, yes. And you said that was a surety bond that has since been canceled?
I don't know. Let's take a look, see if we can figure it out. Let me get rid of some of these. The clock is off ever since the power went out on Thursday, so every time I look up, instead of looking at the computer clock, all right, let me see what I can figure out about Mr. Pendleton. It's not helpful. Yeah, the $25,000 bond is the bond that he's accused of violating. And that bond was canceled by the surety company. So right now he has no bond in that case.
Which case is that?
That's yours, Paul.
The
One,
nine-
no, wait, no, 1020 is Melissa's case. Bond was canceled in that case by the surety company on May 24th. Now let's look at your file.
Is that the right phrase to say that the bond company canceled it, or did they just withdraw the money? I guess I'm a little bit unclear on that.
All right, well, I'll get back to it in just a minute. I think it said, it's a notice of cancellation of bond. It's one of their forms. He canceled bond in your case also. So,
You know, he might have another case that hasn't come through yet.
I'm trying to find the notice of bond violation. Yeah, violation of conditional release alleged to have occurred May 23rd. I think we should start with him.
Sheriff's Office, Sergeant Hasbrook.
Good morning, Sergeant Hasbrook. Judge Middleton calling. We're going to need to see a couple of customers. Could we start with Dylan Pendleton?
Pendleton?
Yes.
Who else you need?
I'm going to need Calvin Bridges.
Bridges?
Christopher Pontius.
Pontius?
I think that's it.
Okay. You want me to bring them all down? Or?
No, we'll start with just Pendleton for now.
Okay.
All right, thanks. Bye. Deborah, I see flashing before my eyes, there are some emails regarding our prelim this afternoon on Dingman. That's all still a go?
That one is a special prosecutor.
Oh, that's right. That's right. That's
Sorry.
Amy. So they're sharing, and I haven't opened it, I'm just seeing them going by. But yeah, it does appear that it will be going at 1.
We have one regarding Joseph May that's still on.
That'll be in front of Judge Pattison. McLean is off because of the competency evaluation. So we're waiting on Mr. Scoggin. Then I'm awaiting waivers on Norris and Engelmeyer. Reggie King is somewhere out there in the universe. Half asleep. Then we've got a bond motion on Pontius, and I think a waiver on the record. And then Bridges, I thought also was a waiver on the record. But I want to free up Mr. Gibson if we can. All right, let's see who we got in the waiting room. The jail. Good morning, Mr. Pendleton. This is Judge Middleton. We'll be with you in just a moment. We're waiting for your other attorney to finish what she's doing. So I haven't forgotten you. I'm just going to put you in the waiting room, all right?
Okay, thank you.
Okay, all right. I didn't just want you to sit there in limbo. Put me in limbo. Well, let's see what we got here. All right, Melissa is back. Let's bring Mr. Scoggin back. Hopefully he can come back in from the conference room. He's back. All right, Melissa, could you come back, and Deborah? We're returning to the matter of People versus Justin James Scoggin. File number is 211042FY. Mr. Scoggin is charged with resisting obstructing a police officer. Had an opportunity to meet with his attorney, Melissa Halleck. The offer is attempted R&O.
Yeah, what we discussed was that Mr. Scoggin was actually intoxicated at the time. He had also had a pretty bad injury to his head that morning and does not remember the incident. I asked him if the video footage from the officer's body cam would refresh his memory. He said probably not. So he would plead no contest if that would be acceptable to the prosecutor.
That's fine.
All right, well, let's talk about that, Mr. Scoggin. What the plea offer is you plead to attempting to resist or obstruct a police officer. I'm not going to do the sentence here today because I'm going to need more information. But that is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. The city would also dismiss the disorderly person charge. And that is file number 2110660M. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you allow or accept that a conviction will enter. One of the quintessential or most common reasons for a no contest plea is you don't remember what happened due to intoxication by drugs or alcohol or a head injury. Sometimes we have people in an automobile accident, they hit a tree and they don't remember anything that led up to that. By pleading no contest, you accept or allow that a conviction will enter because you don't remember. Do you understand?
Yes, sir.
Is that what you wish to do?
Yes, sir.
All right, now I went through the advice of rights a couple of times while you were here. Do you understand that by pleading to this charge, you'll be giving up those rights? You won't have a trial. Do you understand that?
So am I going to jail?
Well, I don't know yet. I'm not going to sentence you today because I want to look at the body cam footage and look at the police report. So I don't have enough information. Does that change your mind about whether you want to plea or not?
I just don't want to go to jail, man.
Well, nobody does, but I don't know what you did. I don't know if you punched him in the head or just...
I didn't punch anybody. I was just living my life. I got hit in the back of the head with a bottle. And
All right.
I went to the hospital to get some staples in my head, and I woke up in jail in the damn chair. And then they were bringing people up to see me like I was an animal.
All right. Well, I don't want to make you do something you don't want to do. I don't know whether you're going to jail because I don't know what you did. And you don't know what you did. All right. So are you willing to plead no contest to the charge?
Yes, sir.
All right. I'm going to set this for the same date, Melissa. You're already here. Let's set for June 23rd at 11 a.m. I don't know either. Maybe we'll have a chance to watch the video together and see what you did.
I don't want to watch that video.
You don't want to watch it? All right.
But,
well, it sounds like you were drunk and had the ability or had the right to remain silent but did not have the ability. All right, so let's see what we got as a factual basis here.
I was just wondering if they were going to buy me a new phone because they broke my phone. And I
Well,
had a phone.
That's probably not likely, but we'll find out.
Or do I have to like open a lawsuit?
You were at 409 Pleasant Street and you were intoxicated and you fell off your bike, had a head injury, you were bleeding from the head and he was carrying a large bottle of liquor.
Yeah, they said that they found me in an alley and then they said that they pulled me over. I was on a bike. They pulled me over into the driveway.
At the hospital, stop. All right, you were mostly resisting because you were drunk. Scoggins tried to pull away and he tried to stand up. He kept resisting me and Sergeant Kilbourne's efforts to keep him seated and under control. Continued resisting while he was being checked out by hospital staff. He acted like he was going to bite the doctor and the nurse that were attending to him. He also kicked me in the belt once. Scoggins was seated in a wheelchair and I was standing in front of him. So yeah, you were not doing real well. All right, I'll accept the plea. The matter is set for sentencing for June 23rd at 11 o'clock. Mr. Scoggin, I want you to go out to the counter and the ladies will give you a notice for that time and date.
Oh.
You can come back to the conference.
How do I go about getting my $500 back from the jail that I had to pay? I have no money to eat.
You posted the bond through a bonding company. You don't get it back. That's how the
I'll get
bond.
my money back?
No, that's how the bonding company makes their money. It was a $5,000 10% bond and you posted the bond. If it was a cash bond, it would be returned. You posted with the bond. They wouldn't make any money if they just gave you your money back. All right, I will see you on the 23rd of June. You go out to the counter and get your notice.
All right.
All right, you're good to go. All right, now, that sounded like a bad night. Bad luck streak at dancing school. Okay, let's bring in Mr. Dylan Pendleton. Mr. Cap is back. I'm not sure what he's doing here. I thought we finished that. Mr. Pendleton, we've got several things going on here. You've got file 211020, which your attorney is Melissa Halleck. It's my understanding you were going to waive preliminary examination in that matter. You also have a no insurance under the insurance code, unlawful use of a registration plate, and driving without a cycle endorsement or no license. Mr. Paul Gibson represents you in the earlier case from February, which is a possession of methamphetamine, carrying concealed weapon, and felony firearm. The bond on the earlier case was revoked by your bonding company, and on the second case, yes, there's an allegation. Now, would you find the misdemeanor file also? There's an ordinance case that's going to be dismissed as part of that. It's in the file. The allegation is that you violated your bond by possessing weapons and methamphetamine in May in violation of your bond condition. So we have to deal with that, and you have two cases set for prelim and pretrial on those misdemeanors. So I'm going to put you in a breakout room with both of your attorneys.
Your Honor, just so that they're aware and there's no no surprises, there is another possession of meth case for which he was arrested on 5/23/21 that he has not been set on, I don't believe. I didn't see a notice set for it when I was looking last week anyway.
Which is perhaps why the bonding company revoked all the bonds on the 24th.
Yeah, that case number is 21-1074 FY. It looks like there is a notice in there now. Let me see when that one's set for. That one is set for pre-exam conference on 6/8/21.
Who's the attorney in that case?
It looks like it was assigned to Paul Gibson.
All right. right, so Mr. Gibson has the first case and the newest case. All right, I'm gonna let you guys discuss that. One option is to kick the can all the way down till next Tuesday. All right, now I have John Cap, who we dealt with earlier, who's come back. Now he's gone. All right, Deborah, I'll let you wait in the waiting room and we'll, thank you. I didn't realize you had a third case. I looked under Dylan Pendleton. I didn't see that one.
Yeah, everything kind of got a little crazy. I actually made a timeline for myself so I could keep it all straight. So, all right, I'll just wait when they're back.
All right. shortly.
What's the plan, guys?
Okay, so he'll waive on both files that are set for today. Most likely he'll be waiving on Paul's other case as well. Wasn't sure if you wanted him at today or just wait till next week. And then the other thing is his bond. He would like to request that right now his bond was canceled in our cases because of the bond violation. With those new charges from the 23rd. He's never missed a court date. He does have pretty steady employment, so we were just going to ask for bond being reinstated.
Well, let's see. I guess we can just go on the record then on the judge is back, and as soon as the breakout room closes, your client will be back.
Okay, that's the plan.
Yeah, I don't know that the inmates have the ability to get in and out of the breakout room, so I just have to wait for the 60 seconds to tick. Thank you for spending time talking with him.
Thank you for the time.
One second. Here we go. All right, welcome back, Mr. Pendleton. We've been waiting while you guys talked in the waiting room, or the breakout room. The case that's, one of the cases set for today, I'll go through these one by one. File 211020 FY alleges possession of methamphetamine, carrying concealed weapon, and felony firearm, which carries a mandatory minimum 2-year prison sentence, plus 3 misdemeanors, are set for pre-exam conference here this morning. File 21972 FY. Your attorney in the first case is Melissa Halleck. Pre-exam conference in the other case, file 21972, is alleged to have occurred in February of 21, February 26th, as a possession of methamphetamine, carrying concealed weapon, and felony firearm. Paul Gibson represents you on that case. There's an allegation that you violated your conditions of your bond by getting arrested essentially for identical charges in May. Then you have another charge from May 23rd, file 211074 FY, which is set for pre-exam conference next Tuesday, June 8th at 9 a.m. And I'm not exactly clear what those charges are, some sort of methamphetamine charge. In your 2 previous cases, your bonding company canceled your bond, meaning they got out from under it. So in the first case, the May 21st case of Ms. Halleck's bond is $25,000 cash or surety. In the earlier case, it also appears to be $25,000 cash or surety. At some point, it might have been reduced to $4,000.
I think 4,000 is in the newest case that's set, which is a charge of possession of methamphetamine. There were no
the 1074 case?
Yes.
All right, I'm not even clear. All right, both of these bonds are $25,000 cash or surety. All right, so we've got a lot going on. We've got 2 pre-exams set for today, a bond violation, 3 misdemeanor traffic cases, and a new felony case set for pre-exam next Tuesday. So, Ms. Halleck, I'll defer to you. What's the status here?
He's prepared to waive his preliminary exam in all files. I know only 2 were set for today. And then he would like to be heard on bond if Your Honor would entertain that today as well.
All right, well, let's do the waivers first, and then we'll talk about bond. What about the misdemeanor? Simply set those for pretrial
Yes, Your
in
Honor, I
July?
believe Attorney Reed had indicated to set those for attorney pretrial, but I had a notice in the file that says that there was an attorney pretrial for those set on 6/8 at 9 a.m. I'm not sure if that was correct.
No, I'm not sure that. Set misdemeanor files for attorney pretrial.
I think they were set because that's when his next PEC is for his new charge.
For July 2nd, 21 at 9 a.m.
Okay, 1 second.
All right, let's talk about the 2 felony cases. Laura, could I have the bind over sheets on Dylan Pendleton, 211020 and 21972? Mr. Pendleton, the allegation is that on these dates you possessed methamphetamine, you were carrying a concealed weapon, and you had possession of a firearm. Let me get the actual files here. You have a right to have a preliminary examination in both of those cases. There is some merit in simply getting the things bound over to circuit court and try to resolve everything at once. But a preliminary examination is a hearing where it must be established that probable cause exists to show that crime was committed and probable cause that you did it. You won't be found guilty or not guilty at a preliminary examination.
Can I get those numbers again? I'm sorry.
211020 and 21972.
Thank you.
I'm sorry, I got interrupted. That there's probable cause to believe that a crime was committed and probable cause that you did it. You're not charged as a habitual offender. Are you willing to waive the preliminary examination on these matters?
Yes, Your Honor.
All right, well, let me read you that language. This is the February 26th case and the May 16th case, not the May 23rd case. I, Dylan Pendleton, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. Here's the operative language. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do?
Yes, Your Honor.
In both cases?
Yes.
All right. All right, now the bonds have been canceled. They were $25,000, and Ms. Halleck or Mr. Gibson, do you wish to speak to those?
Sure, Your Honor. So I spoke with Mr. Pendleton with regard to bond. He indicated that he's been in jail 12 days. He understands that he has a drug addiction problem and has attended Celebrate Recovery or an NA group at a church in Sturgis. He feels he does need, to report to DRC for testing of some type so that he has some accountability, but that he holds a job he has had for some time now at, where did I write that? Midwest.
Midwest.
Yep. He was there for years already. And it's a pretty stable job security because grandfather is also involved. So he will be, he's appeared for court hearings. He will be testing as ordered through the DRC. He has support to get to testing. He's going to have significant fines and costs from these matters, clearly. And so he's going to need to be earning money somehow. He does have a juvenile history, but it sounds like his criminal record is more recent with regard to drug use. And so, but he does admit that he has an addiction and that he needs to get treatment. So he intends to seek out individual substance abuse counseling as well as continue to engage in groups. And as I've indicated to him, to obtain signatures. He knows, he's acknowledged what's happened and, he's ready to accept responsibility, but he also knows that he needs to be working and he does have a place to live. And so he would just ask that Your Honor reconsider giving him reinstating bond so that he can post something. I think it would be fair to say that he may not be able to post bond at $25,000 in both cases, plus an additional $4,000 in a third case. But if you want to see any money in the future, he does need to be working. He's correct there, but so that's what he would ask for today.
Mr. Gibson, anything you wish to add to that, or does that pretty much cover it?
I believe that pretty much covers it, but as she said, the defendant has been at Midwest Tool for almost 5 years. He's been in jail for the last 12 days, and he still does have a job with Midwest Tool, but it would be important for him to get back to work there soon. So he's asking the court to reinstate his bonds. Thank you.
Ms. Davis?
Your Honor, I've spent several hours going through Mr. Pendleton's previous cases, his current cases, trying to get a handle on a timeline of events. It's a bit confusing because one of his cases that we're looking at happened in December, but it was not authorized until March because of some offers made by Mr. Pendleton that he did not follow through on.
That's the newest case, 211074?
No, that's not even the newest case. So I'll go through these and try to straighten it out. Basically, Mr. Pendleton has a very long history of juvenile issues and substance use, MIPs, that sort of thing when he was younger. But it appears that putting him on probations didn't affect his use of substances, and he would repeatedly violate on those. He then, as he gained adulthood, was charged with carrying a concealed weapon, being a gun, and possession of marijuana and a couple other misdemeanors back in 2018. It was then pled down to simply a disturbing the peace. I'm not quite sure why. But he then, in 2020, kind of went off the rails. So July of 2020 is one of his charges that is in circuit court right now. So he was on a bond for that case for most of these other cases that we're talking about. In that
what's the file number in that case?
The file number in that is, the circuit court file is 20-23496FH. And in that case, he's charged with possession of meth, carrying a concealed weapon, which was a gun, and then felony firearm. So that case was authorized back, let's see when it was found over. I want to say that was in August of 2020. So that one is still pending in circuit court. Then on December 4th of 2020, he was pulled over by Sturgis police, alleged to have had meth and pipes, digital scales, and baggies in his vehicle. And at that point, the officers held off on sending that up for their reasoning. And that one didn't come to us then until March. But between then, in January of 2021, there was a 911 hang-up call from his significant other who was living with him at his grandparents' home. And nothing was charged out of that, but there was certainly some assaultive or threatening behavior that was alleged during that incident with his girlfriend. Then we have February 2021, where Michigan State Police Trooper Oakes arrested him, where he's alleged to have shot a handgun into a field outside of Sturgis, admitted to the officer that he did shoot the handgun to test it out. And when he was found only a few minutes after that, there was alleged to be baggies of meth, scales, and a handgun that was loaded and hidden in the door, such that he was concerned for the safety of the officer when searching the vehicle, because he thought the gun could go off if he pulled the door out. He had it hidden kind of in a door panel. So with that, it was a .40 caliber Smith & Wesson. He had an additional magazine for the handgun in the center console with 14 rounds in it. Then we have the arrest on May 16th, where again, Sturgis police pulled him over. He had warrants from the other two previous cases. He gave a false name. The officers found meth and a .45 caliber Springfield XD pistol with an extended magazine and ammunition in the vehicle. He then somehow managed to bond out on all of these, which is probably due to the help of his family, who I understand have some ability to keep him working at Midwest Tool, which is not a reason for him to be out if these are the things that he's continuing to do while he's on bond. But this most recent one then on 5/23 of 21, again, Sturgis police pulled him over. He claimed he only had a pipe in his vehicle, but in searching the vehicle prior to towing, there was a large amount of meth found in those same hidden cubbies throughout this vehicle that he had been caught hiding guns and meth in before. And it's alleged it was 5.5 grams in the one baggie that field tested positive. And in another baggie, there was 0.7 grams of a blue powdery substance that was not field tested due to safety concerns. Defendant claims it was blue Kool-Aid, but the officers are not certain about that. It was sent to the lab. There was also 3 pipes and a broken meth container. He has had other known drug users with him. This most recent arrest, he had Destiny Lilly with him, who had assault warrants out for her arrest. The case earlier in May, he had Eric Branny with him and Ashley Williams. So we're seriously concerned about his ability to safely be in society if these are the things that he's continuing to do while he is out on a felony bond. He has been in the system with us at least since last August, when he initially was arrested for methamphetamine, and clearly he has not been able to get a handle on it to this date. The police officers were so concerned that they contacted me asking why he keeps bonding out and then getting a hold of handguns again. It's a safety concern for the officers that every time they go to pull him over, because he keeps driving without having a license and without having his car registered, they're concerned, rightfully so, that he'll have a gun again. And at some point, he may shoot one of them. So the public safety concern of this, I think, outweighs what they're asking for as far as reinstating these bonds just the way that they were. I would ask the court to increase them significantly. He does have resources through his family to post these higher bonds. He was able to do it before, and the surety company were the ones that then canceled those. So I'm not convinced that he wouldn't be able to post bond, even if it's placed at $75,000 cash or surety for each of the cases. So I'd ask the court to strongly consider increasing the bonds on these 3 cases that are still in district court. Thank you, Your Honor.
Daniel, I think you may need to be in Judge Patterson's court. Which case are you here on?
Chase Hardy.
Oh, we did it at 9. It was set for 9 this morning.
Oh, mine says 11.
He got
He's
time
done.
8. He got 84 days, 85 days credit, 85 days, and an 8-year prison sentence from Judge.
That's what I
Stutzman.
was recommending too. So, okay, appreciate it.
Thank you. Okay. All right, Mr. Pendleton, you raised your hand. I know you wanted to say something, but probably the best thing you could do now is not say anything further. I'm concerned about the guns and the drugs, and you're bound over to circuit court on a gun drug charge. You got arrested on a gun drug charge. In the newest case, the May 16th case, you got a large gun and a 30-round magazine and a bunch of other stuff, and you said you were homeless and you gave a false name. And there's yet one more drug charge coming after that, which I think also involves a gun.
That one did not, Your Honor. The most recent one on 523, he didn't have a gun. It was just methamphetamine.
Anyway, I've heard enough. Bond is denied. I don't know that any bonding company would do anything, but it's 3 times you're out with drugs and guns, and that's a bad combination. So you have 3 of those, plus a new one, which is 4 methamphetamine charges, plus the traffic stuff. You're driving around and you're not supposed to be even doing that. You're just, as Ms. Davis says, off the rails, and it is a public safety issue. So bond is denied in these 2 files. Now we'll do an order.
So what does that mean?
It means if you have $1 million, you can't bond out. There's no bond. Judge Stutzman can reconsider it in circuit court, but I have a feeling he's going to feel the same way I do. There's no need to deal with a bond violation.
Thank you, Your Honor.
You're a danger to yourself and the public. Right now, you just need some downtime. All right, you're good to go. I'd like to talk to the bailiff. Debbie and Melissa, we're coming up on the lunch hour. Mr. Gibson, you're good to go. Mr. Pendleton, you're free to go with the officer. We've got Mr. Pontius, who's kind of floating in the same pond, and Mr. Bridges yet to deal with. Melissa, I did send Reggie King's phone number. Now, Pontius was a waiver on the record and you wanted to make a bond motion. What were we doing with Calvin Bridges? Could I see Christopher Pontius next?
Yes, I'll get an order.
And then Bridges.
Okay.
Engelmeyer, we sent a waiver for.
Yes. You said there's a waiver in Engelmeyer, Norris. So those are en route, and that leaves us Calvin Bridges and Christopher Pontius and Reggie King.
Pontius is.
You said he was going to waive on the record and he wanted to address bond.
Yep.
And what about Bridges?
He is a waiver.
Do we need to do that on the record?
Yeah, I don't see that she said the waiver got signed and sent.
All right. Did you get my email?
Yes, I did.
Okay. He's set for prelim. Reggie is next Tuesday. The simplest thing may be just to leave it on for prelim. Give you a week to talk to him.
Yeah, because him the and he didn't have any information but an address. So Trina just mailed stuff. She did not call the court to see if they had a phone number.
All right, we'll deal with him. Is that you under there, Mr. Pontius?
Yes, sir, Mr. Middleton.
Good morning, sir. Every time I deal with you, you're always polite, respectful, on top of things. Would you take your mask off so we can see you? We're on the record,
yes, sir.
And this is also on YouTube. You're Christopher Juan Pontius.
Yes, sir.
Mr. Pontius, you had that traffic case that was set for court last week, but you got arrested again on this charge. And so we've adjourned that. The lawyers are going to see if they can work everything out. Your lawyer, Melissa Halleck, is here with us, and she indicates that you're going to waive the preliminary examination, and then she wants to address your bond. Is that correct?
Yes. Yes, sir.
All right. Let's talk about this. The allegation is that on or about May 19th in Sturgis, you possessed methamphetamine. That's a felony punishable by up to 10 years and a fine of up to $15,000, but you're alleged as a fourth habitual offender, which makes it a life offense. This is the time and date for a preliminary examination. Laura, could I have a bind over on Christopher Pontius and Calvin Bridges? Now, let me read you the language regarding the bind over. I, Christopher J. Pontius, understand that I have a right to a preliminary examination where it must be shown, I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with a crime. Here's the language. Voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do?
Yes, sir.
All right. How long have you been in jail?
Probably about 2 weeks now, 10 days, I think. 10 days exactly.
Let's see here. I got the jail roster up here. I look at first thing every morning. You've been in jail 13 days.
Oh, okay.
Time flies when you're having fun. All right, Bob, let me finish this. Bond is set in the amount of $30,000 cash or surety. Your lawyer wishes to speak to that. Melissa?
I would just state that he is compliant. He is not a risk to society. He is an addict. His only income is disability, so it's unlikely he's going to be able to post any bond. He has a set address here in St. Joseph County at the 25039 US 12, lot 106 Sturgis. We would just ask that Your Honor consider a PR bond. He's being cooperative, like I said. He has a place to live, and he does receive disability, and he doesn't want to see that impacted. So we would just ask that you consider that.
Ms. Davis, what's your position?
This is a rough one, Your Honor. Obviously, Mr. Pontius has been back in front of us a couple of times in the past few months. He did have a resisting and obstructing with the officer in Sturgis, which is still pending. So concerning that he chose in that situation to fight with the officer instead of simply being arrested. However, in this situation, I believe he was cooperative with the officers, didn't cause any issues. So that is encouraging. And
it was the same officer, sir. Sorry.
Maybe he has learned his lesson with Sergeant Kreitz that should not argue with a large man. But I would leave it to the court's discretion. Obviously, when there's a disability situation, any jail stays, I believe more than 30 days, tend to impact the disability. So I guess with that, I would leave it to the court's discretion of what to do with this bond. Thank you.
I don't know what happened to the bond. He posted a $10,000 cash or surety bond in the early case.
I just got stimulus money and I had it on me, so the jail was gonna take it anyways.
All right.
Kinda sucked, but.
Don't say anymore.
Yes, sir.
Ms. Davis, you accept the waiver?
We do, Your Honor.
I'm always troubled. The defendant is bound over on a felony charge and gets arrested on a new felony charge. That's always a cause of concern. He was also on bond on some misdemeanor cases, which were going to be a trial. When Mr. Pontius is tracking straight, I get along with him just fine. He's always very respectful, polite. I find him to be intelligent, thoughtful. When he ain't tracking too straight, not so good. In light of the fact that you're out on a $10,000 surety bond, I'm reluctant to do a PR bond. I will reduce this bond by a factor of 10. I'll reduce the bond from 30,000 cash or surety to 3,000 cash or surety with all the same conditions.
Are there testing conditions on that one, Your Honor?
Yes, there are.
Thank you.
All right, Mr. Pontius, like Ms. Davis, I'm cognizant of the fact that when you're on disability, you're in custody for more than 30 days, you can lose your disability, you have to start all over again. But if you keep shooting yourself in the foot, you run out of toes. So I've reduced it to 3,000, and I'll accept the waiver. The matter will be bound over to circuit court, probably maybe combined with the other case and your traffic case. I know the lawyers were gonna try to see if they could resolve everything all at once. All right, you're good to go. I'll do an order to that effect.
Your Honor,
yes?
When I was arrested, the Sturgis police had me convinced that I was gonna get out the next day, and they kept my property. So my bank card and all, and the money I did have in my, I don't want to say purse, but my satchel is all at the Sturgis police station still.
I don't know.
Can I have?
I don't think they would have kept it at the Sturgis station. I can email the officer and ask.
See if we can find out where it is.
Yeah, and it may be in his property at the St. Joseph County Sheriff's Department.
It may be at the jail. So check with the officer there also to see if your property is there. All right, Mr. Bridges, you're good to go. We need Mr. Bridges and then we're ready. All right, good luck, sir.
Yep, thank you.
Good morning, sir. Are you Calvin B. Bridges?
Yes, sir.
This is Judge Middleton. I'm over here at the courthouse. Your lawyer, Melissa Halleck, is with us. Also is Prosecutor Deborah Davis. The allegation in this case is that on or about May 15th that you did possess methamphetamine and flee and elude a police officer. This is the time and date for the preliminary examination in this matter. Your lawyer indicated she had discussed this with you and you were willing to waive the preliminary examination, have the matter bound over to circuit court for further proceedings. Is that correct?
Yes, sir.
Let me tell you a little bit about that. You're from Indiana. In Michigan, a preliminary examination needs to be held or waived in all felony cases. It's a hearing where there must be established there was probable cause that a crime was committed and probable cause that the person charged did it. You don't get found guilty or not guilty at a preliminary examination. This is that time. So let me read you what that waiver says. It says, I, Calvin Bow Bridges, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court in the charges in the complaint and warrant. Is that what you wish to do?
Yes, sir.
All right. It will be set for a status conference in the circuit court, but it may be some weeks to do that. Bond is presently set in the amount of $30,000 cash or surety. And if you post that, you need to stay in contact with your attorney. If you don't, they'll bring you up for all proceedings. All right, sir, you're good to go. Thank you.
Thank you.
Thank you, Aaron.
Ms. Davis, you accept the waiver?
We do.
I think that finishes everything we have except Mr. Reggie King. And
Yeah.
Melissa, my proposal would be we simply set it for a prelim next Tuesday at 1, where he's already set. And, and then you can talk with him in the meantime. Is that acceptable?
Yes.
That's fine. I would just ask that if you do make contact with him before the end of the day and see that he does not wish to have a prelim, let me know so that our staff doesn't do the work of doing all the subpoenas and everything.
Knowing Mr. King, my guess is he's gonna want a prelim, but you never know.
All right. Well, thank you, Your Honor.
And I'll put Melissa will call defendant.
He has a misdemeanor offer is what I have. So.
Well, if he's acceptable, I won't be able to do it today. I'm going to be tied up all afternoon, but if it is acceptable we can do it at some point.
Oh, wait, no, it's not a misdemeanor. It's an attempted RNO. So he still has to waive.
No, he doesn't. Attempted RNO is a district court misdemeanor.
Mm-hmm.
Oh, it is? Okay. An attempted RNO was the offer.
Yes. So if he wants to accept that, just let me know. I'll tell the staff to hold off on doing subpoenas today.
Oh.
And
yep. Hopefully by the. Okay.
All right. I've got lots of work to do to finish this and get ready for our 1 o'clock hearing. All right. We will.
Thank you, Your Honor.
End this record. Thank you.
Yep. Bye.
Bye. And we will